Hello, everyone. My name is James Mathis. My friends call me Jamie. I am a partner in Husch Blackwell's corporate law group, and I lead the firm's commercial transactions practice group. I hope that all of you are staying safe and healthy in these unprecedented times. We here at Husch Blackwell are in full work from home mode, the third week of that, in fact. So if you hear birds chirping, dogs barking, kids playing, hopefully that will enhance your experience. We here at Husch have put together a rapid response team to help our clients face the uncertainty that they are now experiencing in their relationships with their key suppliers, vendors, and customers. Today, we scheduled this webinar and we'll share with you the best practices that we have identified as we have all been getting a refresher crash course with our clients' help in the various contract clauses and common law concepts that excuse performance in unforeseen circumstances like the current COVID-19 pandemic. Before we begin, I need to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I'd like to take a minute to highlight a few of those for you. If you have any questions during the webcast, please submit your question via the question box, Q&A box. At the end of the program, we will answer as many of your questions as time will permit, but if you require a fuller answer or if we run out of time, we can always follow up with you by email, so watch out for that email. We appreciate audience participation. Please do submit questions. It will help everyone on the call learn. There's also an icon to assist with your viewing preferences. Note that you can expand your slide area by clicking on the maximize icon on the top right of the slide area or by dragging the bottom right corner of the slide area across your screen. If you have any technical difficulty, please click on the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck and additional materials are available in the resource list icon. It looks like a folder at the bottom of your screen. For those of you who need CLE credit, who are attorneys, this program is pending approval in Illinois, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin. Once the program has been approved, we will update the certificate of attendance link within the email that you will receive tomorrow following up this webinar. To report your hours in Illinois, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. You may also download the certificate of attendance from the certificate widget at the completion of today's program. A recording of this webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you. Please feel free to forward that link to anyone that you think might benefit from it. And that's the housekeeping. I'd like to introduce today the two speakers that are joining me, Katie Giannossi and Wendy Proctor. Katie will be first. She has over a decade of experience with Husch Blackwell's commercial transactions practice group. Clients trust Katie's guidance in drafting and negotiating the key bet-the-company contracts that are critical to ongoing operations that keep their businesses going and growing. Katie is located in our Chattanooga office. Katie will speak first. She'll be talking about just the general concepts that we all, those of us who are attorneys, all learned about in law school, but honestly, on a day-to-day basis, usually have not had a lot of opportunity to practice. And with that, I will hand it over to Katie, and I'll introduce Wendy when she speaks. Katie, take it away.
All right. Thanks, Jamie. I'm going to pull up our first slide here. So if COVID-19 related events cause a delay or other issue in performance of a contract for the supply of products or services, the legal remedies available to excuse the performance will depend on the specific contract language, individual facts and circumstances at issue, and applicable law. The applicable law will be specified in the contract, but it's possible that other laws such as civil codes will apply based on the jurisdiction where performance occurs. Our team at Husch Blackwell has the experience and resources to quickly advise on all types of force majeure issues with respect to the impact of applicable laws and otherwise, and including foreign laws and civil codes. And there's sometimes also industry-specific considerations. But for this portion of the presentation, I'm going to focus on the three remedies typically available under the law of most states to excuse a party's failure to properly perform its obligations in contracts for the supply of goods or services. These are contractual force majeure clauses, the doctrine of impossibility, used interchangeably with impracticability, and the doctrine of frustration of purpose. These theories have similar elements, generally excusing performance when an event beyond the party's control either delays or renders performance nearly impossible or defeats the purpose in which the contract was based. First, note that the force majeure rights are only available if and as specified in the contract and may benefit one or both parties. The doctrine of impossibility typically benefits vendors and service providers, and the doctrine of frustration of purpose is usually successfully invoked by purchasers. While each contract and situation is unique, any force majeure type analysis has got to include an examination of the entire contract, applicable law, and associated facts and circumstances, and should include an examination of the parties' relationship. A good first step in any analysis like this is to step back and just to quickly assess the overall monetary and other value of the contract at issue and the overall nature of the parties' relationship in general, under the present circumstances, and in the future. The contract language is critical, but this practical assessment can better inform decision-making and can also help prioritize reviews. Based on the applicable facts and circumstances, and particularly in this current environment, it may be that the best path is for the parties to work out an amendment to reflect their mutual agreement as to how immediate and future risk will be allocated or reallocated between them, and to make associated revisions to the parties' contractual rights and obligations. That said, from a legal perspective, it is very important to quickly identify and take any procedural or substantive steps required to preserve contractual rights. For instance, relief under the force majeure provision may not be available unless the impacted party provides written notice of the force majeure event or its impact within a specific time or generally stated time frame. Each party should also consider whether it has any existing rights under the contract that have not been exercised or waived, and that could still be invoked to mitigate the impact of any performance issues. Another time-sensitive remedy to keep in mind is whether there are reasonable grounds for insecurity as to the other party's performance, in which case a demand for adequate assurance under the UCC could be made. So moving on to the force majeure analysis itself, the first step should always be to identify the events and circumstances that are impacting performance. The fact of the pandemic itself may or may not be that event, and the pandemic itself may or may not fit within the definition of force majeure in the contract. But resulting events and circumstances that are also beyond the party's control and may otherwise fit the definition should be considered. Always consider the manner in which performance is impacted. What exactly is going on? Is performance prevented entirely, in part? Is it delayed? Is the claimed force majeure event a primary or direct cause of the performance issue? And what does the contract call for? While the force majeure provisions and standard terms of certain industries may have some general similarities, there is no standard force majeure clause for commercial contracts. As a result, you've just got to look at each one. I mean, we're positioned to help make that review quicker, but the specific wording of the force majeure clause of the contract and relevant facts and circumstances have got to be reviewed to determine the applicability of the clause before the scope of available remedies or need to rely on extra contractual legal doctrines is considered. For example, the contract may not have a force majeure provision. You may look at it and say, I don't see any reference to force majeure, but that's not important. There may still be a force majeure type clause referring to perhaps acts of God, maybe not, or just events beyond a party's reasonable control, may or may not be listed as having to be unforeseeable. Some of the force majeure provisions will benefit both parties, but not all of them. And even when it's a clause that can be invoked by either party, the remedies may differ. Some contracts will define force majeure broadly as any event or circumstance or one or the other beyond a party's control or reasonable control. And at times the definition further requires the event or circumstance, like I said, to have been unforeseeable. It may specify that the event doesn't exist if it was caused by the affected party's fault or negligence in any way, or if it could have been avoided through the exercise of reasonable efforts. At times, specific events are listed as examples of force majeure. At other times, it's sort of a full listing of the following events constitute force majeure. In general, a court would narrowly construe the clause And in the absence of a catch-all definition, would look to the surrounding language and intent of the contract to determine whether the particular event at issue is of the same type or class as those that are specifically listed. On the other hand, some clauses may say that there are certain obligations that will not be excused by force majeure in any circumstance, such as the obligation to make payment. And it's common for economic hardship to be specifically excluded from the definition. That's a hard case to make, but at times it's successfully negotiated in, and certain types of economic hardship may be in the force majeure clause specifically. Even if a contractually defined force majeure event is found to exist, many contracts and many clauses will say that there's no relief from performance unless the impacted party provides certain notices, and at times perhaps they have to take certain efforts to remove, avoid, or mitigate the impact. And as Jamie will discuss, even if the existence of the triggering force majeure event is conclusively established or agreed, the types of relief available to each party and other resulting circumstances under the contract will differ. It's risky to examine the applicability of the force majeure clause in isolation. It could be impacted by the balance of the agreement, or there may be other rights and remedies in the agreement that are relevant. In the entire agreement clause of the contract, it kind of says what are the terms that form the parties' contract should be confirmed to ensure that if there's terms that are referenced in, that they don't conflict or supersede with the agreement that you're, the document you're reviewing. And then always keep in mind, have there been amendments, and what is the impact of those amendments on the analysis? Another consideration is that it might be possible to request adjustments to performance obligations by change order. And then kind of stepping back, always check first that this contract is in term, but then is it, especially if it's a long-term supplier services agreement, are we looking at 6 months before expiration or 6 years? What is the relative risk to each party based on the value of the remaining term? Similarly, if a party has a right to terminate for convenience, that may significantly impact the importance of the force majeure analysis. The same goes for any right to prevent a renewal. And then if you're looking at those rights, also consider what are the rights and liabilities that would be triggered if there is a termination for convenience or if a non-renewal is noticed. Limitations of liability should also be considered just in analyzing the risk under a contract. Is there a specific cap if there's a unavoidable breach that is not excused, so to speak? And is there a sole remedy for a specific breach? Or a liquidated damage? Does the contract provide that if there is a certain type of breach, that the available remedy is something specific, or there's a cap on liability, or liquidated damages are the only remedy? And then indemnification obligations should also be considered in evaluating overall risk, whether they're triggered by a breach and whether they're subject to a cap. Again, looking at the agreement as a whole, just looking at the force majeure clause may be a mistake if there are other rights and remedies available, especially with respect to suspending performance or allocation, canceling an order, or a scope of work. It could be that the right cause to trigger those rights does not exist, but it may be that those were negotiated to be available in a party's discretion or reasonable discretion, or that the circumstances that would justify the triggering of those rights are broader than the force majeure definition. And then, of course, look at the dispute resolution procedures and provisions and any shift in the responsibility of costs of litigation to understand the overall impact of the force majeure analysis. And finally, the governing law provision of the agreement should be reviewed to determine what other applicable laws might provide remedies if the force majeure clause is absent or not triggered. So especially if the force majeure provision it doesn't provide the needed relief, the availability of relief under the doctrines of impossibility and frustration of purpose can be examined. In general, they excuse or permit delay in performance if there's an unforeseen event beyond the party's control that either delays or renders performance nearly impossible or defeats the purpose in which the contract was based. This is a factually driven analysis, and the exact scope of available relief will vary by state somewhat. The doctrine of impossibility may provide a party with relief if the party's performance is made impracticable due to an unforeseeable event occurring through no fault of the impacted party, but only if the non-occurrence of that event was a basic assumption of the contract. This doctrine is available for the sale of goods under the UCC and also for service agreements through the restatement of contracts and common law principles. The impact on performance doesn't need to rise to the level of impossibility, but a party must show that it's more than a mere increase in difficulty or cost that's at issue. It's often governmental regulations or laws that prevent or adversely impact performance are frequently analyzed as events that may support a claim of impossibility, so long as the law was passed after the parties entered into the contract. On the other hand, the continued existence of certain market conditions is generally not considered a basic assumption of contracts. So by itself, a disruption in market conditions usually does not justify a claim of impossibility. At this point, in general, this doctrine in the past has been used to excuse performance by sellers or service providers, as courts recognize it's rarely impossible to provide payment. And if this doctrine is applied, the scope of relief available will differ based on the facts and whether the impracticability is temporary. And the parties' relationship and relative sophistication are also relevant because the court will examine whether the risk of the event at issue was a business risk that the parties assumed in entering into the contract. And finally, the doctrine of frustration of purpose may excuse performance under a product or service agreement, where the party seeking excuse no longer has the motivation to perform that originally induced its participation in the contract, but only if the principal purpose for which the party entered into the contract is frustrated, so that continuing performance makes little sense. Typically, the bar to demonstrate that the frustrated purpose truly was the primary purpose is high, and the frustration of purpose must be so severe that it is not fairly regarded as within risks assumed under the contract. Frustration of purpose is a counterpart to impossibility in that it's generally employed to protect buyers. Like impossibility, when the frustration is merely temporary, the obligation may only be suspended and not fully excused or terminated. In the current environment, we have and expect to encounter many novel and different interpretations and proposed applications of both of these legal doctrines. At this point, I'll turn it over to Jamie.
Thanks, Katie. I think Katie has done a great job of outlining really the broad categories of rights that exist and obligations that exist in a force majeure type of event like we have now. Before we get to my presentation about the practical considerations and how you can develop a process and how you should reply or how you should initiate any sort of issue that arises with your contract, I think it's necessary to talk about a couple of the questions that we've seen in the Q&A box. Wendy, who will be following me, I'll speak for about 15 minutes, is going to be dealing with the special real estate aspects of force majeure clauses, because force majeure, particularly in a leasing context, to a lesser degree in a property sale context, is a little different than a standard run-of-the-mill commercial contract to buy widgets or services or other matters like that. So I'm going to leave those questions for her. I should also mention that I have some bored teenagers hanging around my house, and so they helped me put together some memes that are peppering the next portion. Hopefully they'll enrich your experience. Let's talk about the review process. What is our goal? If we have a situation where we feel that our performance or the performance of our counterparty might be affected by COVID-19, what should we be looking for? I'll talk about specific goals in a second, but the first overarching goal that I think all of us should look for should be achieving for our clients, whether they're internal for in-house counsel or whether they're whether they're a client in a typical law firm situation, is we should be trying to get them certainty and predictability. If you think about this current situation with COVID-19, that's what we all crave, whether we're talking about making sure that we can continue to get groceries in the house, or that we can make sure that we stay healthy, or the stock market, or, any number of things. And really, as you think about it, that's probably the overarching goal that we all want if we're dealing with uncertainty with our vendors, our suppliers, our customers. So what do we want? Contractual certainty. I think everyone can identify probably with this slide who has a client or who is a client. Specifically, how do we get there? I think one of the things that we as attorneys need to challenge our clients to tell us is, we understand there's uncertainty. Where do you want to end up? Sometimes that answer may not be clear, particularly if our clients are the ones who believe that their performance is the one that's affected by COVID-19. Here are some themes that run through the conversations that we've been having with the clients. Sometimes our clients will want to be able to suspend their performance, because I had a call a couple of days ago from a client who had 5 of their production line employees test positive for COVID-19. And so they were either going to have to shut down, or they were going to have to limit their production. And so they want relief from their obligations under their agreement with their customers. It's important to note that most force majeure clauses and most of the remedies from force majeure involve a suspension of performance or involve a delay. Sometimes they can involve a termination, and we're going to talk a little bit about how to get to that point if that is what your client wants, if this event of force majeure is one that would require them to want to terminate a relationship. And then not only identify the goal, and this will come in that 30-second elevator speech when you're speaking to a client or to someone in your organization that needs your assistance. What is the concern? Is the concern that we can't perform, that we can't meet our contractual obligations? Are we concerned that the counterparty cannot meet their contractual obligations, either because they've gone silent, maybe because we know where they're located and we know that there is a shelter in place or stay-at-home order. We worry that they're not an essential business. And then finally, maybe there's a concern about market conditions. Maybe you're buying widgets from Acme Corporation and you fear that the widget market is going to dry up. That's typically not an event of force majeure, but sometimes the doctrines that Katie talked about can also help there. And Katie already talked a bit about this process. I think if you are in a situation where you have a lot of contracts, whether that's for your supply chain, whether that's for your customers, it's important to set up a process if you believe that your customers are going to be affected by COVID-19 or your suppliers. I would set up a process and a standardized process to quickly be able to get all of these items out of your agreement. Or if there's not an agreement, is it a battle of the forms? Try to gather what the documents are so that it can speed your review, or if you use outside counsel, our review. The next step then is communicating with your counsel, but as importantly, communicating with your counterparty. It really will help to get to a point where you at least have clarity in the situation. There are some other advantages. If you are above board, if you are upfront about telling a counterparty to your contract, hey, we're not sure we're going to meet our obligations, to the extent at least that you have the right under your contract or under common law to claim an event of force majeure, or to claim impossibility or impracticality, or if you're on the buyer side, mostly frustration of purpose. That will help you in any sort of litigation that arises with clean hands. It can also, in some circumstances, trigger a counterparty's obligations to you once you inform them of that. Certainly, if you tell a counterparty, hey, we can't meet that order, regardless of whether it's force majeure or not, they then, under common law, under the UCC, have a responsibility to mitigate their damages in the event that you would be responsible for damages to them. We're going to talk about adequate assurance a bit later as well. All of these dialogues do two things. First, they try to get us further down the road to resolution. And second, they give us knowledge about what a counterparty is facing, and if there is some way that we can help them to meet their obligations if we're concerned about them being able to perform. Let's talk about adequate assurance. I think adequate assurance is a remedy that can be especially helpful in COVID-19. There are advantages and disadvantages. One of the disadvantages is that, as Katie was mentioning, all of these circumstances are very fact-specific, whether that's because there is no real standard force majeure clause or whether it's just because there are differences in the relationships that parties have with each other. Adequate assurance, however, is a right that, unless taken away by contract, parties have in order to ask the party that they are contracting with if they can perform, and to, in fact, demand some sort of assurance that the party is going to be able to perform their obligations under the agreement. Most of us who work with commercial contracts, who work in this space, have had lots of opportunities to demand adequate assurance. But I would bet that if we were to take a survey right now, if we had a voting button, 99.9% of you would say that the only circumstances in which you have asked for adequate assurance has been in that circumstance where your customer is late paying its bills. You see a headline on Yahoo Finance or in the local paper that says that, you know, they've defaulted on some other obligations. You heard from the bank that they're slow paying. And so adequate assurance in that context is something with which we're all familiar. Adequate assurance in that situation generally takes the form of a letter of credit or putting them on, you know, cash on the barrelhead terms or something else. Most of us have not had the opportunity to deal with adequate assurance in a situation like this. Let me give you another example. I got a call a few days ago from a client that was a defense contractor that had been under a federal order classified as an essential contractor. That order went further to say that the vendors that were supplying components to that essential government vendor were also deemed essential. And so for that client, it needed to be able to perform on its contracts with the government. It was not sure that its vendors could get it the components. And so that client asked us to prepare a letter that it sent to its vendors, demanding adequate assurance, making sure that they could perform on their obligations. And also, the letter doesn't just have to be 2 lines that demand adequate assurance. It also said, oh, by the way, here's a copy of the federal order. We are an essential vendor. Therefore, you are an essential vendor. And so if you are facing any sort of orders from your local municipality, from your county, from your state, you can have this letter to show anyone that questions why you're still in business. That was an adequate assurance demand, but it was one that helped start the conversation, that tried to get to yes, or at least tried to get to certainty for our client. Let's review, and we all probably learned about this in law school, those of us who are attorneys. The demand for adequate assurance does a couple of things. All of the determinations that are made, however, in the adequate assurance process really rely on reasonability. You have to have reasonable grounds for insecurity. I'm not sure during my career I've ever seen a situation where it is as clearly reasonable that some of our clients have reason to be insecure, to think that their counterparty will not be able to perform. The requirement then is that you make a written demand for adequate assurance. Use the notice provision, as Katie mentioned, that you'll be looking for in your contracts. And here's what adequate assurance does. If you don't receive adequate assurance and that adequacy is determined by you and has to be reasonable, then you can suspend your performance. Typically, if you are a customer, that means that if there are any sort of process payments that relate to the items that you have not yet received or the services that you've not been given the benefit of, that means that you can suspend payment. There may be some other items there where you can suspend your performance in ways that would be helpful for you. I noticed a lot of the questions that we were getting in the question box while Katie was speaking revolved around this question of, okay, how soon is too soon to declare an event of force majeure? How soon is too soon to inform the counterparty? I think if you're asking that question, and again, all of the circumstances are going to be determined by the contract that you're dealing with, if you're dealing with a contract. If you're already asking that question, it is, in almost all cases, probably fine for you to start having that conversation with your counterparty. And again, if you're worried about your counterparty being able to perform, there's no downside for demanding adequate assurance. We have another meme here, assure all the aggrieved parties. Why? Why is that important? It's important because the other side of demanding adequate assurance, at least under the UCC, is that if that assurance is not received in a commercially reasonable time, the counterparty is deemed to have repudiated that contract by not giving that assurance. Again, there's no hard and fast rule here. This is where the individual state's governing law and the case law in that state is going to matter, right? Because again, that assurance has to be reasonable. I wish there were a hard and fast rule, but all contracts are different and all situations are different and all state laws are different. Now, if you get to that point, repudiation becomes a bit of a rabbit hole that you go down. Again, because you have the ability, that repudiation doesn't have to be explicitly accepted by the party that was initially aggrieved. It can be, and that gives that party, essentially that permits that party to terminate the agreement and to make it clear that the agreement is terminated. But again, this process of adequate assurance is, I think, one of the best tools that we have in our bag if we're worried about the other party's performance to get us certainty and more quickly. It probably bears mention to talk about what a commercially reasonable time is. That is certainly very dependent upon the circumstances, but if you are the one giving adequate assurance, it is fine for you to put in that letter, in that adequate assurance demand, a deadline. Have some reason to back it up. It shouldn't be arbitrary. It should be reasonable. That's what the law requires. But if you have an obligation to your customer that you need fulfilled, back up from that time and indicate to the party that you're giving adequate assurance demand to, hey, we really need to know by X date. Papering that sort of communication, again, if things go badly, if there is a dispute, if you end up in litigation or arbitration, can only help you. Let's talk about some other considerations and resources and some other practical tips. We, like many other service providers, have provided a spot on our website that has all of the best thought leadership that we have, all of the advice that we think that we can give in a general fashion about COVID-19. You will see our white paper about force majeure there. You'll be getting a link to that in the email that you get tomorrow. One of them that is very useful, and that gives you some tips. One of the other most useful things on that site that I have found in my practice is that first link on the PowerPoint. We have compiled, and our government affairs attorneys have compiled, a list of all federal, state, and local orders that affect business, that affect, quarantines, that where stay-at-home orders, essential industry exceptions to those orders. All of that is compiled there. It's updated every day, right around midday. It is an invaluable resource, and it's an invaluable resource in a couple of ways that are relevant to this conversation. One, if you're worried that you have a customer that you can't reach and you know where they're located, you can look at that page, go to the state, and under the state link at the bottom of that page, there will be links to all of the counties, all of the cities in that state that have given that order. It's been invaluable both in determining whether you need to take action if you are worried about your counterparty, but also it is a way for you to get quick advice if you are worried that one of those orders will affect your ability to perform under your contract. And so you can see that more information is better. Sharing that information about why you are affected by an event of force majeure or why your purpose is frustrated can help you as you go through these processes to try to get more certainty for your contract, for your procurement department, for your clients. I've also linked there the main coronavirus page that we have. Whether you need information about SBA loans, something that could also help you to avoid having to declare force majeure, right? And all sorts of other resources that can help you. I would encourage you to go to visit that site. We're going to try to leave about 15 minutes at the end for answering the questions that we can answer that have come in from the Q&A box. I see it's been very active, so thank you for that. I'm now going to turn things over to Wendy Proctor. Wendy heads our real estate practice area's COVID-19 thought leadership group. In more normal times, Wendy concentrates her practice on reviewing, negotiating, and drafting complex lease agreements for landlords, tenants, and developers across the nation. During her 25-year career and prior to joining Husch, Wendy was in-house real estate counsel for national retail companies and developers, including one of the nation's largest mall real estate investment trusts. Wendy, like Katie, is also in our Chattanooga office. Wendy, the court is yours.
Thank you. Thank you, Jamie. I have to say, as Jamie mentioned, I've been doing this for 25 years, and up until about a month ago, I don't know that I ever have had to really delve too deeply into force majeure provisions in the real estate contracts. But, you know, as you can imagine, for the last couple of weeks, that's consumed, I would say, probably 90% of my time talking to landlord clients and tenant clients who are trying to navigate through this situation, particularly those who are in the retail sector where, you know, stores have been closed down, malls have been closed down, restaurants can't fully operate. So it's definitely a scary time for the whole industry. With regard to the real estate contracts, with regard to the real estate contracts, I think, you know, the biggest areas where a force majeure will affect a party's obligation to perform would be, you know, things like completing construction, completing repairs required by a lease or alterations required by a lease or a contract, an ability to be open for business. Lots of times, if you're operating under a commercial lease in a retail setting, you have an obligation to operate for business in your lease. So force majeure could impact that ability. An ability for, say, a landlord to deliver possession of a space on a timely basis because of a force majeure event. And to the extent that the performance of the obligation is tied directly to this force majeure event, then that would allow potential, you know, delays in those types of things. The one big area where you don't necessarily have relief under a force majeure event if you are a tenant under a lease would be with regard to the payment of rent. Most commercial leases will specifically say that an event of force majeure does not excuse the payment of rent or other monetary obligations, which I guess on the flip side of that, I would say that if you have a landlord who owes a construction allowance, force majeure would not excuse a landlord from paying that either. So it, you know, it goes both ways, although I should point out not all force majeure provisions are created equal. I just looked at one yesterday, and the force majeure provision was drafted entirely to benefit the landlord and didn't even account for any force majeure relief for the tenant. So you really do have to look at the language in your document to see, you know, who it benefits. Is it really mutual, or is only one party able to avail themselves of that type of claim? I would say more often than not, the force majeure provisions I've seen are generally somewhat reciprocal. It's more unusual, I think, to see it only favor a landlord, and probably pretty rare that it only favors a tenant. The first thing, though, you need to do is determine, you know, we're looking at the situation here, and is COVID-19, is that a force majeure event under your lease? So, you know, taking a look at the language is important. If you have a provision that talks about, you know, acts of God, circumstances beyond the control of either party, or, you know, sometimes even there will be specific references to pandemics, epidemics, and things like that. So if you have broad language or a specific reference, then I would, I think COVID-19 would definitely be considered a force majeure event. Where I think it gets a little fuzzy in the context of your lease situation is where, the tenant is trying to be mindful of the health and safety of their employees, their customers, and thinking, the threat of the virus is such that I need to stop operating. And then you might have the landlord on the other side saying, well, we're not stopping you from operating. So if you choose to stop, you need to continue to pay rent because there's no reason you can't. The threat of this isn't enough to excuse your performance, and, we're not interested in abating your rent during this time. I think it's still a little early in the game to know exactly how that's going to play out, but certainly I think, if you're a landlord, you are going to want to point to the language in your lease where, assuming your force majeure provision specifically says it does not excuse the performance of rent. Another tool in a landlord's toolkit is frequently a lease will be drafted with a specific obligation or specific language to provide that the obligation to pay rent under the lease is an independent covenant. And so no matter, what may or may not happen in other areas of the lease in terms of breach by landlord or force majeure events or whatever, that obligation to pay rent exists independent of everything else. So if you're a landlord and you have a lease where your force majeure provision says it doesn't excuse the payment of rent and, you've got this independent covenant to pay the rent, I think that definitely gives the landlord kind of a 1-2 punch to try to make a pretty strong case that this would not excuse rent payment. So that is something, obviously, you have to look at your lease to see what it says. Ultimately, I think, there's probably going to be some litigation around all these issues and an area of law that hasn't had a huge amount of new case law to create new precedent. We're going to start maybe in the next few years seeing some things that may affect how these provisions are handled going forward. Let me see here. In the event of a force majeure, then a tenant could be excused from meeting some of their lease-imposed obligations, like to complete the construction, like I mentioned a minute ago. Also, if there's a provision in your lease, which typically you will find that the tenant is required to comply with applicable laws, then if you have a situation of a governmentally mandated closure, which we are starting to see on an increasing basis with regard to retail in particular and restaurants, I think then, that gives the tenant a much stronger argument, to excuse the performance of their obligations under the lease. It's still early to tell, but I do think that the longer this were to continue, the stronger a tenant's position would probably get, because, if they're not able to operate, they're not able to make any money, and this is such an unforeseen event, there's impossibility of performance situation that exists. So, we'll kind of have to see how that all plays out. We hope it doesn't last for very long, but at this point, I don't think, we just don't know. And then in terms of the obligations or what exactly can a landlord or a tenant do, in the short term here to try to manage through it or navigate this situation. So I think both sides, and I think, Jamie, you talked about this in your presentation, and that is really important to communicate. I think that, if you're a tenant, let the landlord know what your plan is, what you think you can do. If you think you're going to need some kind of short-term relief to get you through, I think that asking or having that conversation earlier is always better. And if you're a landlord, I think it's good to kind of make everybody aware, this is what's going on. We're all aware of it. We need to get through this. So the open line of communication is good. Lots of times, if you want to make a claim for force majeure, a force majeure event, you need to give a written notice in order to kind of set the groundwork and start the paper trail. And of course, it would be important to send that notice per whatever notice requirements are in your lease. So if you're supposed to copy 3 other places when you send it, make sure you do that if you're a tenant and if you're a landlord. So definitely, I would say try to develop your paper trail on either side. I think, I've seen a lot of letters that have been kind of all across the board from tenants to landlord clients where, some tenants are, just saying this is what we're going to do, and they don't really, try to create a conversation. Other tenants have taken maybe a more softer approach and said, this is what we need to do. We'd like to talk to you about this and figure this out. Some landlords have taken a very proactive approach where they've sent out letters right off the bat and said, we're not going to have any rent abate. We're not going to abate rent during this, so don't even ask. Now, is that maybe some posturing? Perhaps. Will there be some further discussion? I'm sure, and depending on, different tenants may be more successful, even with landlords that initially take that position. I think as a practical matter, a good approach to take would be to try to get the conversation started. If tenants are going to get through this and be able to remain open and operating and stay viable over the long term, then the landlords are going to probably need to work with them to some extent and offer some relief to them in the short term, which I think is in also a landlord's best interest, because if at the end of the day all of the tenants leave, then the landlord would have empty space and nobody to fill it, and they're getting no rent ever, or for a long period of time. So it seems like the impetus should be on both sides to try to approach this kind of from a problem solving mindset. And I think there are several kind of options available to both landlords and tenants in terms of trying to figure out what are some ways we could approach this to make it more manageable for the tenant, but also protect the landlord's interest. A landlord could offer, say, a deferred rent situation where maybe you don't have to pay rent for 60 days or 90 days, and then you'll pay it back over X number of payments within this amount of time. Some landlords may decide that, it's more important to them to have some rent coming in than no rent. So they might say, give me 50% and I'll forgive the other 50%, or give me 50% now, then we'll defer the other 50%. Occasionally, maybe, they say, we'll abate the rent and we'll just add the abated period to the end of your term, and, we'll get it at the back end. A couple of other scenarios I've seen is, if a tenant has a security deposit, you could have the conversation with, can I apply my security deposit to this month's rent? And that way, the landlord is still getting the money. The tenant isn't having to come out of pocket for that money. Another situation, which won't apply in all cases, but if you have a landlord where a construction allowance is owed, you could talk, a tenant and landlord could, look at the idea of, well, let's just offset the allowance against rent as it becomes due. That way, the landlord doesn't have to write a check to pay out any money right now. The tenant doesn't have to write out a check. That approach may be more appealing or less appealing depending on how, from an accounting standpoint, that might, affect a landlord's balance sheet. I don't know. And at this point in time, maybe everyone's just trying to get through it and not as worried about that as they might normally be. But those are some things, that you could certainly look at or try to explore with your landlords. Most of the people I've been talking to, my recommendation has been, let's try to start the conversation, and let's try to, approach it in a way, whether you're a landlord or a tenant, that, you're willing to work as business partners to figure out a way to get through this. And I think ultimately that's really what's going to be necessary at the end of the day. One of the things that I had quite a few people ask is, what about my insurance? I have business interruption insurance, or I have I have rental interruption insurance. Unfortunately, at least based on what I've seen so far, most policies do not cover this type of a situation, primarily because in order to have an insurable claim you can make, it requires usually property damage, and there really isn't any property damage in these situations. I know some people have sort of tried to explore the idea of, if this virus is, because it's contagious and it's in your space and you have to go out, now these these germs are all over your space and you have to do all this deep cleaning or replace furniture, like now you have suffered a casualty and you could maybe make a claim to, related to that. I don't know that that's going to be a successful approach. What I think is probably a better solution, which is being lobbied for at the moment, but I don't know if it will be successful, and that would be if the federal government, as part of, the relief that the legislation they're trying to pass right now, after the CARES Act, would be to set up kind of a business interruption fund and create some ability for, people that work in the retail, particularly, not so much office, but probably mostly retail sector, to get some relief and get them through the next few months, both landlords and tenants. Another area, and I think Jamie touched on it as well, is, if you qualify as a small business, then there are the SBA loans that are available, and that is another avenue, which I think we're still early in the game to figure out, what that process exactly is going to look like. I think we're supposed to know here soon, know more soon. But that's certainly something that if you qualify as a small business owner, you would probably, you should explore and see if that might be an option. And I know some people say, well, what about, there's a covenant of quiet enjoyment in my lease. If that's breached, couldn't I claim that, don't I have some relief under that? Typically that's because that is only available if it's something the landlord has caused. So because this is really outside of the landlord's control, especially if there's a governmentally mandated shutdown, I think that's a more difficult claim for a tenant to try to make. It doesn't really feel like it fits this situation to me. So at the end of the day, what are the things like after this, what exactly are you supposed to do? I think the first thing you always do is, read your lease, take a look at what does your force majeure provisions provide? Is there anything else that, might give you, if you're a tenant, some options? If you're a landlord, take a look at, obviously, what your options are as well per your lease. I think it's important that we all stay focused on the health and safety of, our employees and our customers, keeping that open dialogue, like I mentioned, trying to partner in a solution. And also, I think, we are very early in the game. I do think that, even though landlords want their rent and lenders want their mortgage payments, mass foreclosures and evictions really are not a preferred outcome. So I really do hope that, everybody, and I think that people are going to be motivated to try to avoid those types of outcomes, because those really won't put anybody in a better situation at the end of the day. And then if I were a landlord who has a lease form, or if I'm a tenant who has a lease form, I'd probably take a look at the forms I'm using, and I would recommend maybe beef up this is the time to beef up that force majeure provision to address this type of situation in a way that makes sense. The best thing about being able to enter into contracts is you can decide at the front end how you want to handle different situations that arise. Unfortunately, no one's ever encountered this, so nobody ever contemplated it before. But now that we have, we can maybe more proactively try to come up with language for going forward, so we're not all scrambling around trying to figure out what our options are, and try to just establish it up front, so that in the future we don't have this issue. I wanted to mention a couple of resources that Husch has to offer. We are offering to clients, if they want to have their leases reviewed and recommendations developed in a notice letter or whatever the next step is, assistance with that. We are offering a $500 per lease flat fee to do that. So if you want some guidance and some help with that, certainly, feel free to use us as a resource for that. And obviously, small business owners, if that's if the SBA loans is something you want to explore, we have a lot of resources and can kind of guide you through that process as well. And that's all that I had, Jamie.
Great, thank you, Wendy. We have a ton of great questions in our inbox, 48 to give you a number. So we've got 4 minutes left in the scheduled hour. We can go over 2 or 3 minutes. So we'll try to cover some of the themes that these questions are hitting. But what we will do is we will follow up with email to see if we can, give you kind of a short answer. Some of the questions, the short answer will be fine. Some of them are a little longer and more detailed. Couple of themes, one of which is there were a couple of questions about whether the demand for adequate assurance concept covers services agreements or rather whether it just covers agreements for the sale of goods. UCC just covers sale of goods, at least by, on the 4 corners of the document. What we have found is that many states have, by common law, even after the UCC, extended that concept to services agreements. And there is also a body of case law that precedes the UCC that really was kind of the impetus for the adequate assurance process. So the same concepts still apply, even where we're talking about a sale of goods, the different state laws do matter in the common law in those states. Couple of other questions, and this one I'm going to direct to Katie, and is one that I encountered earlier today. What about drafting a force majeure clause now? What should the parties keep in mind, Katie, if they're wanting to enter into an agreement? How should they deal with COVID-19 in that force majeure clause?
Yeah, I think there's definitely going to be a lot of things to keep in mind. Obviously, all of this is no longer unforeseeable, and that can always be an important consideration if the force majeure clause is limited only to the unforeseeable. And I think a lot of it as well is because you can't dream up every single possibility, but since there was, specific facts and circumstances, perhaps you're covering it in the force majeure clause, but perhaps it's more specific than that, and just making sure that each party has that certainty of process and of how the risks are being allocated between them if a similar event were to happen again, and depending on the timing of the negotiation in the shorter term. I do think that's what will be key. The force majeure clause needs to be reexamined, but also this circumstance itself may be something that's worthy of separate treatment.
Thanks, Katie. And I can tell you, I have had clients that have decided to go both ways. I have had some that are drafting a contract right now that have decided to carve out COVID-19 because their view, both parties' view, it's been agreed to, is that even though we may not know how this is going to turn out, we're both entering into this contract and kind of accepting the risk that it's just baked in the cake, right? And I have had another client in another contract decide that they wanted to indicate, hey, even though COVID-19 this pandemic is ongoing as we're entering into this contract, we don't know where it will end up. And so any further unforeseen circumstances associated with it can be considered a force majeure, so kind of kicking the can down the road. Other questions or themes of questions that are coming up. I've seen a couple that talk about a force majeure clause that does not carve out payment obligations as an obligation that are subject to force majeure. Katie or Wendy, in the real estate context, how do you feel about a standard force majeure clause? There's really no such thing that doesn't have the standard carve out that says, but oh, by the way, payment obligations can never be relieved by force majeure. Have either of you encountered that situation?
I think once in a while you do this as Wendy, you do run across that. I guess I would always also take a look, though, to see, is there an independent covenant? Is rent, the payment of rent, that obligation an independent covenant? Because I think the landlord still has a pretty strong argument that there's no excuse for the payment of rent. Where I think this situation gets very unique and very and may be handled or treated differently than what we've typically seen in the past is, usually you're talking about maybe a hurricane comes in, or maybe steel shipments aren't readily available, so you're delayed. I mean, they're things that happen, but usually they are, in the big scheme of things, resolved relatively quickly. We're in a situation here where we don't know how long this is going to last, and the longer it lasts, I just think you end up, with a potential like public policy argument, for lack of a better term, where it's if this were to be litigated, where I think the judge is going to say there's just no way you can expect somebody to pay rent for 4 months when they aren't able to be open and operating, or the reality of the situation may start to make more of a difference than the four corners of the document. I think that, it's always, the tenant is always going to have the uphill battle to say, I don't have to pay rent, but certainly I think the circumstances of this specific situation we're in today, to me it feels like if ever they were going to try to find a way to accommodate, if it were to go to court, it seems like they have a pretty good narrative to present.
Katie, do you have a thought on that in the commercial contract context?
Yes, I think there's some similar kind of themes and arguments, but if it weren't accepted, these are the circumstances where, a delay in being able to make payment for some reason so as to avoid remedies for non-payment being triggered seems equitable. And again, it gets to what is the remedy at issue, and if there's continued delay, are there rights? I think it is fact specific, but the situation in particular does kind of open up the reasonability of that concept of having the failure to pay within the scope of force majeure, and perhaps it just is going to trigger kind of more detailed discussion of what the parties' expectations are if it's not accepted out.
Yeah, for me, I tend to think that performance obligations are still disfavored as being, subject to force majeure. So I would want my justification if I were trying to claim that as an event of force majeure to be bank was closed, or, our CFO was in hospital and he's the one who has the passwords. But, and this segues into another question that someone asked about, hey, do we think that courts are going to be more receptive to force majeure claims going forward? Yeah, I think we're in the great unknown in a lot of ways, and I think they will be more receptive. If they're, will they be, how much more receptive they'll be, that's just a guess from all of us. Thank you all for joining us for our program today. We do still have a lot of unanswered questions in the inbox, and I promise that we will get back to you. It won't be through this since we'll be shutting this down in a moment, it won't be through this web platform. We'll be sending you an email. And it may be one of us on this webinar that sends you an email. There are some more pointed questions that I saw that it will almost certainly be somebody from a different practice area that will be sending you an email. But we really thank you for joining us, taking an hour now and 4 minutes out of your day, or 5. We hope that the information that we provided was helpful for you and your organization. If you have not already, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback will assist us in providing future quality programs. Just as a reminder, this program is pending approval for Illinois, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin CLE credit. I know we have one question about Kansas CLE credit. We will get back to you on that. Once the program's been approved in all the states where we seek approval, we'll update the certificate of attendance link within the email that you'll receive tomorrow. A recording of the webcast will be available tomorrow for you. You can forward it to your friends, to your colleagues if you think that it would help them. And that link will also have some links to some of the resources that we talked about here. Please, if you have any questions, email any of us on this call. We would love to hear from you. If you have anything more pointed, if you want to just talk about some of these issues, please reach out. Please stay safe, keep your families safe, keep your organization safe, and again, thank you for joining.